I don't mean to laugh, but I think I did this before. I really don't watch my videos because I already know what I said. I tried a couple times and I sounded kind of preachy. I hope I can refrain from that in the future. Okay, I knew this a long time ago, but a lot of people don't know. So I put in there, when was qualified immunity created? Okay, that's the question I asked the internet. I'm pretty sure I did a video about this, but it's really stupid when they did it. Qualified immunity's roots trace to a law passed in 1871, but the Supreme Court established the doctrine in 1967 case Pearson versus Ray, introducing a defense for officers acting in good faith. The court later refined a standard of the 1982 case of Harlow versus Fitzgerald, setting the current requirement that immunity exists unless the official violated a clearly established constitutional right. And I've been showing you everything about your constitutional rights, and they're not a given, they're earned. Okay, so but they give qualified immunity on good faith, but see, you don't know all the laws they're breaking as far as your constitutional rights go. You have no idea what effective assistance of counsel means in the Sixth Amendment of the U.S. Constitution, and that's the requirements of the Rule of Professional Conduct and the Code of Judicial Conduct, okay, are set forth, for the Sixth Amendment, effective assistance of counsel. And those are the laws for all lawyers and judges in a court of law. And everybody's denied effective assistance of counsel. If your lawyer hasn't gone over the Rule of Professional Conduct with you, that's where deprivation of rights starts, because it clearly states in the preamble that they're supposed to, educate you on the law, and what your rights are. They're there to counsel you, not to take over. Okay, they're a counselor at law. Okay, so 1870, Congress passed a law, USC 1983, to allow individuals to sue government officials for money damages when they violated constitutional rights. That's where you get the constitutional crisis. Your constitutional rights are being violated. But you can sue for that. That was intended to protect African Americans from racial terror following the Civil War, but it also filed for lawsuits against officials who violated the federal constitutional rights. Remember, I told you, any law repugnant to the United States Constitution is null and void. Nobody should even think about it, but they do. But that's deprivation of rights. That's okay, the Supreme Court's role. 1967, the Supreme Court first recognized the concept of qualified immunity in Pearson versus Ray, protecting officers who acted in good faith with probable cause in an unclear legal situation. They arrested some preachers because they were sitting in the colored section only and they weren't colored. And the cop said, hey, the sign says colored people only, you're white. And they tried to explain to them they were just having a cup of coffee and discussing, they traveled down south to promote, get people to vote, register to vote, and, educate them, show them what their rights were, and try to help them. So they got arrested for sitting in the coloreds only section, and when they went to court, the judge said, well, sign on the wall. They thought it was a law, but that's in violation of the rule of law. The penalties for violating the rule of law are harsh. I did a video on the penalties for violating the rule of law. The doctrine evolved to require plaintiffs to prove that their right was clearly established at the time of the violation. I see that in a lot of those driving by stop and frisk, where people are in their car and they get pulled over and they're literally citing their constitutional rights. The cops know and they don't care. It's all about feelings, egos, attitudes. They expect you to jump when you approach. Okay, critics argue that the modern version of qualified immunity has become a major shield for government officials and police, making it difficult to hold them accountable for misconduct, especially excessive force. Well, thanks to technology, you have videos. Anytime you hear "quit resisting," you're about to witness a murder. That's just for people to say, "Oh yeah, I heard him quit resisting." But if you're there, you don't have to resist. I mean, you'll see. There's so many videos of people not resisting and getting the hell beat out of them. So it's easy to show that your constitutional rights have been violated, especially in a court of law, when your assistance of counsel is ineffective because he didn't even discuss the rules and the codes, the mandatories, the legal obligations of all lawyers and judges with you in a court of law, the rule of professional code, the judicial conduct, so that you may have reasonable information to make an informed decision before giving informed consent. And yet, have you ever given informed consent to the proceedings? And most of you objected when you get in a court of law, and then when you try to say something to the judge tells you to shut the hell up. Your lawyer will speak, but see, your lawyer's not doing his job. In the code of judicial conduct, it's mandatory for the judge to allow you to speak, to speak your piece, speak your mind. If your lawyer is in violation of the rules, the judge knows that. The opposing party knows that. And it's mandatory to report it. They don't report it, thus depriving you your right to effective assistance of counsel. And the only way your lawyer is getting away with being an effective assistance of counsel is because the opposing party and the judge is allowing it. They're not reporting misconduct. Reporting misconduct is mandatory, thus committing misconduct. And then the judge allowing this to happen in the first place is in contempt of the very court they preside on. And I've had people literally citing the judges and the lawyers for violations of the rules and the codes, etc., etc., and they just ignore it. So they're openly and willingly denying. It's easy in a court of law because nobody's telling you anything about what I'm telling you about. Okay, but that's a ridiculous standard, a good faith measure. They thought that was the law. The sign on the wall said colors only. That was a good faith standard. And ever since then, they've been throwing around this qualified immunity like they can do all willy-nilly. And that's acting under the color of law, which there are penalties for acting under the color of law. There are penalties for deprivation of rights. There are penalties for a conspiracy against rights under the color of law. Them saying other than what I'm telling you, that would be disinformation. There are penalties for disinformation. That's violating the letter of the law. There's penalties for violating the letter of the law. All right, people, I just wanted to let you know where I was going because I'm going to start confronting people directly in the future. So I need to, keep you up to what I'm going to, when I say what I say, when I say it. Okay, that's all I want you to understand is, and I will mention these laws in the penalties form to everyone I confront about what they're doing. But what do you think? All laws legally are required to be in the public interest. It's a legal mandate. I did a video on that. And So is this good faith standard in the public interest? I beg to differ. It's in the interest of the bar. You know, scales of justice have always been on a monetary scale. So yes, this was in the interest in the bar, not in the public interest. And anybody can hold me to the letter of the law on that, as I will you in any court of law. The Constitution clearly, not directly, but indirectly, say every law, everything must be in the needs of the many. In the needs of the many, not the greed of the few. All right, number peace and love, people. All right. May your Creator always be with you. May He always rain many blessings. I wish you a long life and good health. I do. And I always do, because mine is horrible. I don't want you to go through what I'm going through. And if we could stop this living under the color of law, our public servants acting under the color of law, but we got to do this together. I care less about your political background. This is an apolitical movement. This is about getting things constitutionally correct. Okay? This is about abiding by the law. Laws you never heard of. You want accountability. And that's what I'm doing. I'm going to try to get you accountability. Okay, I want to make these laws as public as possible, so I have to start confronting those that are making them and breaking them. But the only way I could do it is on the internet. I've been filing paperwork, started a couple things in 79, then in 81, 82, 83, 84, and I rarely got an answer. And I used a lot of laws that I read about. And I kept looking for more. Never hurts to keep looking. It's better to know and not need it than to need it and not know it. Good night, all.